honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket this morning, LaShonta Renee Jackson versus the Florida Highway Patrol. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. I would like to reserve 5 minutes for a rebuttal.
Okay, duly noted.
May it please the court. My name is Julie Fine, and along with co-counsel Jack Fine, we are here on behalf of the appellant, LaShonta Renee Jackson, on behalf of a personal representative of the estate of Vontavia Kira Robinson. We are asking this court to reverse the summary judgment entered by the trial court because the record facts show that FHP owed a duty of care to the decedent, and FHP's negligent acts were not protected by sovereign immunity. It's essential that this court recognize that the facts of this case involved a dangerous situation controlled by FHP. FHP responded to and took control of something called a smoke fog incident, which FHP knew was a particularly dangerous and unique type of roadway hazard. And we know that FHP knew that because 4 years before our crash, FHP created a standard operating procedure for handling smoke and fog hazards. And that was after a 70-car pileup on I-4 in Polk County left 5 people dead and 37 people injured. After that crash, FHP investigated, researched, and concluded that the extreme reduction in visibility was predictable and the crash could have been prevented. There were legislative hearings, there was training, there was a policy enacted, there was even an interagency agreement that was signed by FHP on how to protect against this exact situation.
Well, counsel, what is the specific duty that FHP owed your client?
The appellant has 3 different duties that we believe apply, or has alleged 3 different duties apply here. The special tort duty applies because FHP became directly involved in circumstances which place people within a zone of risk by creating or permitting the dangers to exist or subjecting the drivers to danger. They also undertook a service. So the undertaker doctrine applies, and they increased the risk of harm to those on the roadway by opening up the roadway. So there's also the undertaker's doctrine, which is a common law duty. And there's also a duty to warn because FHP created a known dangerous situation by opening a roadway that was not apparent to those on the roadway, and they had knowledge that those on the roadway could be injured by this condition.
Well, let's explore that a little bit. What if FHP received a phone call that there's, a smog condition, at mile marker 334, and it took them half an hour to get there? Let's assume that's a reasonable amount of time to get there. And this crash had happened while they were traveling there. Would there have been a duty?
No, there
Why?
wouldn't have. I believe that Pollock is that situation where the law enforcement haven't arrived on scene. They don't have control over the risk at that point. They aren't controlling it, and so they don't have a duty. And in fact, that exact situation happened earlier that night. At 11:30, there was a crash, and FHP had already been warned. The exact same Pollock situation happened in our case because the forestry called FHP and said, hey, you guys need to patrol the highway because we think that it's going to get worse in the early morning hours. You need to be there. And FHP says, okay. And they entered it into the CAD, but it got closed out. So it wasn't passed on to the night shift. So actually no one came to patrol the highway and crashes occurred. So that's exactly what happened earlier in the night. But then FHP does respond, and they're on the scene, and they took control of the roadway. And they actually were in control of that risk, whether or not people were going to be driving on the roadway or not. And they made the decision to open the roadway and not to warn anyone, and in fact, not to even stay on the scene, but to leave the roadway to just see what happens. And we have assets on standby if we need to close it again.
So Counsel, how are they then in control of the circumstances if they have also at the same time left the scene and aren't there at all?
So there's absolutely no facts in this record which which says that they weren't in control of the situation. They might not have been on the scene, and that is an allegation that we say is negligence. But Lieutenant Gorley adamantly insists, as does FHP in their agency response, that they were still in control of the situation and that they were monitoring it. He had assets on standby in case he needs to close down the roadway. He had assets reporting early for duty that morning at 4 a.m., but they weren't on scene yet. So the situation is ongoing, and he knows that. And he said it. He said, we don't know what's going to happen in an hour. We might have to close it down again, but it looks okay at this moment. But there's a policy in place which is supposed to prevent law enforcement from just making a decision by driving up and down a roadway to see which way the wind is blowing. You're not supposed to do that. That's not how you decide if wind is blowing a certain direction. You call the weather service and you ask them, hey, which way is the wind blowing? You get a spot weather forecast for that area, and that wasn't done.
So, counsel, you make a good argument that there may have been some negligence involved, but my understanding is that that's not actually the issue in this case. The issue is whether a law enforcement agency owes a duty to your client, and my understanding of Appellee's position is that it's a Category 2 decision under the Trianon case, and for that reason, there is no duty owed, regardless of whether they could have done it differently, regardless of whether what actually happened was negligence. There is no duty because it's under Category 2.
So I believe that the appellee and the trial court kind of had some conflating about sovereign immunity and duty. Trianon does, as Your Honor says, apply strictly to duty, and we don't need to even dispute whether or not it's a Category 2. If we conceded that it's a Category 2, a special tort duty arose here because law enforcement became directly involved in circumstances which placed people within a zone of risk. This is exactly the situation Pollock talks about, where in Pollock they say the special tort duty doesn't even apply in this situation because no one came to the scene or had any control over the facts or the situation. But here, law enforcement does come to the scene. They're on scene. They're controlling the risk. So that control of the situation places people within a zone of risk because whatever they decide to do, if they make negligent decisions, that subjects the drivers on the roadway to harm.
In what way are they controlling the risk here?
They're controlling the risk because if they don't handle the smoke fog incident appropriately, if they make decisions that are not reasonably careful, then they are going to subject people to harm potentially because there's a smoke fog incident occurring right here. This is something that they know exists, and it's also something that's predictable and preventable, and you prevent it by following the checklist, which they didn't. So the risk is opening a roadway where there's a hazard. That's how they're controlling it. They are the only people in charge of who gets on that roadway and who doesn't get on that roadway.
But whether there's a hazard literally depends on which way the wind blows.
Well, the hazard is there. Whether the hazard is going to affect drivers and at what time, it's not known. But the fact that there's a potential danger, you need to be, I think that it's, tort law is to be reasonably careful in that situation. If there's a danger, you need to be reasonably careful to make sure that someone's not subjected to that danger. And you can determine whether or not that danger is there by contacting the appropriate experts and not just driving up and down a roadway and thinking you know which way the wind is blowing when it's 3 a.m.
So
But you concede that if FHP didn't learn of the smog incident, or B, if they weren't able to get to the site within a reasonable amount of time, there would be no duty.
If they were not on scene, your B scenario, absolutely. I'm not exactly sure if they didn't know that there was a smoke fog incident. I believe that's correct as well. I think that if they didn't know about it, how could they be involved in it? They have to have some control over the risk, and if they don't arrive on scene and have that control, then they don't have a duty.
And then one more question. If they had conflicting reports, let's say one weather source says it's going away, wind's gonna blow east, the other one says wind's gonna blow west, you would concede there wouldn't be a duty there if there was conflicting advice from the meteorologist?
I think the duty still remains whether or not there's causation or whether or not there's a breach. I think that those are different questions. I think when you control a situation, when law enforcement officers become directly involved in circumstances which place people within a zone of risk by doing certain things, either creating the dangers or permitting them to exist or just subjecting people to danger, then a duty arises. Whether or not they breached their duty because there was conflicting information, and let's say they followed the checklist and he made a decision, hey, I followed the checklist and I thought I made the right decision, that would be an issue with breach. It's our argument.
So let me just follow up on that point. So it sounds like you're arguing this, that there's a duty to behave reasonably, to act with reasonable care, right? You're defining that, or at least in part defining that, by virtue of the policy, what the policy says that they are, the appropriate way to handle a fog smoke incident on the roadway. So assuming that's the case, we have Pollock that tells us that a policy might do that. It might talk about whether or not the behavior was reasonable or not, whether it was negligent or not, but it cannot create a duty, right? So can you tell us how you think the relationship of the policy, or whether or not they're checking the list, relates back to the actual duty to your client?
Again, Your Honor, I believe that the policy does not create a duty. That is not what we're saying. We don't believe that the policy created the duty. What Pollock says is that after explaining the special tort duty, it says the premise underlying this theory is that a police officer's decision to assume control over a particular situation or individual or group of individuals is accompanied by a corresponding duty to exercise reasonable care. So their decision to assume control over a particular situation is what establishes the duty, not the policy. The policy shows the breach. It also shows knowledge of the known danger. It's evidence of that they know that this is a dangerous situation, and it's also evidence that sovereign immunity doesn't apply because these are operational acts, because there's a policy and we're critiquing the way that this policy was implemented, and not about whether or not the policy itself was a good policy. We think the policy's great. There's no comment on the policy. We just think that it wasn't implemented properly. And I would like to save the rest of my time for rebuttal. Thank you.
Thank you, counsel. Counsel, you may proceed.
May it please the court, Britt Thomas from the Office of the Attorney General on behalf of the Florida Highway Patrol. Because we know that this case falls under Category 2 of the Trianon delineation of responsibilities, and because we know by virtue of the Supreme Court's case in Pollock that the public duty doctrine applies here, which provides that there is no duty regarding FHP's exercise of its authority under 32105, that is, patrolling the state's highways, controlling the flow of traffic thereon, and enforcing the traffic laws. That does not engender a duty to any individual, and as such, there must be some other common law duty or statutory duty in order to sustain a cause of action against the Florida Highway Patrol. So the question becomes very quickly, are there any exceptions to the public duty doctrine? And we would submit that there have been none presented to this court, and you heard none here today during appellant's presentation. First, in regard to the zone of risk, even a cursory review of the zone of risk jurisprudence reveals that, as applied in governmental tort litigation, at no time did FHP place this decedent within a zone of risk. A couple of the facts have to be stressed in this matter. That is, FHP had no contact whatsoever with this decedent. He was entirely unknown to FHP. Therefore, he had no idea whether and to what extent FHP may have been on the scene or not on the scene or anything that they may have done. By the time he came through this portion of the interstate, the roadway had been open for some 35 minutes.
Counsel, how does that relate to the, I think it's Pinellas Park versus Brown case, where there was no direct relationship between the police officers and the plaintiffs? But my recollection, and I apologize, and you can correct me if I'm wrong, is that they did find that there was a zone of risk.
You are correct, Judge Winokur. There was a duty found in the Pinellas Park v. Brown case, but that was also part of the reasoning behind the court's decision, in that includes that there is always a common law duty when law enforcement is operating vehicles and when the injury that is at issue is a result of the operation or the negligent operation of those vehicles. The court also found in that case that it was entirely unreasonable that the incident that gave rise to the response was in fact a gentleman running a red light, and at some point there are 20 law enforcement vehicles chasing this individual. So the court, I believe, was outraged at the absolute, what you might have even referred to as gross negligence in that case, and did apply the zone of risk. But again, there's always a common law duty in regard to the operation of vehicles and the use of guns, or the negligent use of guns or operation of vehicles. So I think that case is easily distinguished from the case that we have here. Back to the zone of risk, the Wallace Supreme Court case has created a disjunctive list of the exceptions to the public duty doctrine, and that's what we're talking about here today. That includes that there was a creating or a permitting of dangers to exist through the custody or detention of an individual, or otherwise subjecting individuals to danger. Because we know there was no custody situation, no detention situation, we're really talking about whether and to what extent FHP placed this decedent within a zone of risk by creating or permitting dangers to exist and subjecting this decedent to those dangers. So in listening to the appellant's presentation, she would have you believe that the danger that we're talking about here is FHP's actions. That is not what the danger is in this case. The danger is the fluid and volatile conditions of visibility that are resulting from both a wildfire event that happened the previous day combined with atmospheric conditions of fog. And I don't think the evidence in the record is able to tell you specifically exactly what combination of those things resulted in the visibility issues. But we know that that is the danger. So FHP did not permit that danger, did not control that danger, and otherwise was not responsible for that danger. They're responsible for what they do on the roadway, and that roadway was closed for 3.5 hours after the incident that happened at or around midnight. During the entirety of that period, FHP is monitoring these conditions, and it has to be able to exercise its discretion when it deems it appropriate to reopen the roadway. That's the duty that it's responsible for under 32105 Florida statutes, and it is that responsibility that is entitled to the protections afforded by the public duty doctrine. So,
Would you, Counsel, would you acknowledge that FHP controlled the circumstance at the time of the closure during that 3-hour period where the road is closed?
At the time of the closure, yes, and during the pendency of that closure, yes, they did control the situation, which is they're controlling the flow of traffic in that area. They're not controlling the smoke, fog, or visibility issues. They're monitoring those, but they're not controlling those.
So at what point do you draw the line where you say that they no longer are in control?
They were no longer in control when they opened the roadway to the normal flow of traffic. There
Even
is-
though at that time they remain on the roadway, they're continuing to patrol, they're continuing to evaluate the circumstances, and at least purportedly for the purpose of controlling traffic flow on the roadway.
Judge Long, that is correct. They're continuing to fulfill those responsibilities that they're required to fulfill pursuant to 32105, which is the monitoring the roadway. But we know that those responsibilities do not give rise to any individual who might want to bring a cause of action against the FHP. There just simply is no duty in that regard. We also know from the jurisprudence surrounding these kinds of issues that FHP can in fact, and law enforcement can in fact, withdraw from situations. We know, for example, in the Wong v. Miami-Dade case, the Supreme Court found that there is no obligation, even if a law enforcement agency becomes involved in a situation, there is no obligation on behalf of that law enforcement agency to remain there for any period of time that may be suggested by a plaintiff. Rather, they must have the discretion to withdraw those personnel at the time at which they deem it appropriate to do so. In this particular case, that's exactly what FHP did. They reopened the roadway at the point at which Major Gurley had made a determination based on all of the circumstances that it was appropriate to do so.
Even if that determination is in violation of their policies?
Judge Long, I think that what you have here, and a closer look at this policy, reveals that there was no violation of any policy. Yes, there was a highway safety smoke management agreement. This was a loose agreement that was entered into between the Florida Highway Patrol, the Department of Transportation, and the Florida Forest Service. And I would defy you to find a provision in this smoke management agreement that was violated in any way as a result of the facts of this case. There is no violation of this agreement. In fact, the agreement doesn't really contain any specific requirements themselves. Additionally, when we're talking about this checklist that has been roundly discussed during the litigation of this matter that's now been going on almost 10 years. Likewise, you hear a lot about the checklist, but what you don't hear so much is the actual policy to which that checklist is appended. That policy provides that shift commanders shall utilize as necessary the appropriate checklist in addendum 714.1 through 714.19, and that is the checklist. So the checklist itself is entirely discretionary. You're counting on your troopers in the field to understand and know which of the items on that checklist that they need to do and which in a particular situation they need not do. And it's not a violation of the checklist or the policy that one or more of those items is not completed.
Well, maybe you could take us back to maybe the 100,000-foot level, and let's go back to the statute. What is the department's or FHP's duty with regard to a smog incident on the road under the statute?
Well, under the statute, they're obligated to control the flow of traffic and to monitor the roadways for public safety and to enforce the traffic laws.
So there's a balancing there of the risk posed by the smog, but also controlling the flow of traffic and goods that go down the interstates.
There is, in fact, Judge Rowe, a balancing there, and that's part of what we argue when we talk about the police emergency exception. There are risks for members of the public in this particular case, no matter what FHP does. And you see, even in the excerpted testimony that we provided, that Major Gurley provided, but even more so in his expanded testimony and deposition, you see that he's engaging in this planning process while he's in the field and trying to make the best determination he can in the interest of public safety. And the reason that's important is because Major Gurley's concern includes not only the visibility issues on I-75, but for 3.5 hours, they have now been diverting traffic onto these rural ancillary roadways, a situation that was exacerbated by the fact that US 441, the other only major north-south thoroughfare here, is also closed. So they're diverting the traffic. There were crashes on US 441 as well at or around midnight. So it was also closed. So they've now been diverting this heavy traffic that's only getting worse for 3.5 hours. And Major Gurley is monitoring the conditions, and in fact, it is unrefuted that the conditions at the time the roadway was reopened were in fact clear and appropriate to begin the flow of traffic again. There is no question about that. We had a gentleman from DOT who testified, Robert Allen Martin, who said he's driving down the roadway at literally 10 minutes before this accident happened, and the visibility was absolutely fine to begin the resumption of the flow of traffic. So he's out there as well, and if you talk about the smoke management agreement, Major Gurley was using that agreement to the well, he was not probably looking at it, but he's doing those things that are attendant to ensuring the public safety. He had Department of Transportation on site. They were speaking to the Florida Forest Service the evening before. They had put out fog and smoke signs that were still there. So there was, in fact, a warning, because those signs that are described in this agreement were actually on the roadway and as requested by FHP. Additionally, Major Gurley had asked for message boards because the roadway he was contemplating it was going to remain closed. And he had those staged in the event that there were visibility problems again. But his concern was for the entirety of the area, not just I-75, and that is his responsibility. He's diverting traffic onto roadways, motorists who are not familiar with these roadways, vehicles that are not suited for these kinds of roadways, the big tractor-trailer rigs. All of that increases the possibility of accidents happening because of the diversion of the traffic. Additionally, he's not sure, even though he doesn't have any reports of visibility issues there, he's not sure what visibility issues may exist out there in these roadways. And it was absolutely unrebutted that was itself a dangerous condition that Major Gurley was responsible for and had to pay attention to, which went into his decision in regard to reopening the roadway. Back to the question of the zone of risk. I mean, it's clear that the department or the Florida Highway Patrol did not, in fact, create or permit dangers to exist. The danger was the visibility issue. And they didn't otherwise subject this decedent to a danger. Again, he was entirely unknown to FHP, and this fact makes a big difference no matter whether you're talking about the Pollock Supreme Court case or other cases where they find that there is no duty owed under the public duty doctrine to begin with, and there especially is not a duty because there's no undertaking in regard to this decedent, and there has been no express promise or assurance upon which that decedent was relying. So there just simply was not a duty owed to this particular decedent.
Thank you, counsel. Your time has expired. I will ask the clerk to add 36 seconds for the appellant's rebuttal.
Thank you, Your Honor. As for a lot of the arguments that counsel was making about the balancing of risks, that is a jury question. Was Lieutenant Gorley being reasonably safe in this situation? That's something for a jury to answer. It's not a duty analysis, and it's not a sovereign immunity analysis. So I don't believe that this court should be considering those things when determining whether there's a duty or sovereign immunity. I also want to point out that the clear visibility is a red herring. FHP is not supposed to be determining whether or not the visibility is clear. They're supposed to be following this checklist, because when these conditions are present, it often appears like visibility is clear. There's a reason why the policy doesn't have law enforcement officers driving up and down the road to determine whether visibility is clear. That is not one of the things on the checklist. They need to contact the weather service. They need to do a labori index, because this cloud of smoke drifts back and forth and is susceptible to micro climates. And so it's unknown whether or not it's going to be right there within a specific at that moment, but there's a risk involved. And so whether or not it's visible for Lieutenant Gorley, he's not supposed to be making that determination by just driving up and down the roadway, which is not the policy. The fact that counsel mentioned the fact that the decedent was unknown to FHP, and I think that Your Honor brought up the Pinellas Park case. There's also other situations that do not involve vehicles or guns that use zone of risk analysis. And there's the sting operation with Brown v. Miami-Dade. There's a foot chase at a festival, which is Miami v. Hong de la Cruz. There's the custody of the escaped convict at a hospital, which is a first DCA case, I believe, and it's Sams v. Ulrich. There's, and specifically within Keisner v. Kolb, there's footnote 2, which says, we implicitly recognized this distinction in Trianon when we noted that some activities of police officers in carrying out their duties, such as the way motor vehicles or firearms are used, may be actionable. We do not consider these two examples to be an exhaustive list of all possible actionable activities involving law enforcement officers. So it's not just the Supreme Court specifically says those are not the only two considerations to have. There's a policy in place to specifically address this discretionary, as the opposing counsel says, decision to stop the individual, the law enforcement officer, from making such a discretionary decision. He's supposed to be following this checklist, so he's not making an uninformed decision, and he makes an informed decision. I think it's very important that this court recognize that FHP is in control of a smoke fog response. It's not opening a roadway. We would not be here if they were just merely opening and closing a roadway, because the danger involved is not the opening of a roadway, it's the smoke fog hazard. That is what they are in control. The risk to others is that hazard. That's the issue. And they control whether or not people are subjected to that hazard. They control that risk. And this is distinguishable from Wong in that the law enforcement created the risk, and so they must take steps to avert the danger, and that's failure to warn. And I would just ask this court to reverse the summary judgment. The trial court erred by conflating the issues of sovereign immunity and duty, misapplying the relevant standards, and mischaracterizing the governmental actions alleged by plaintiff.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.